Welcome back, everybody, to Public Law. In this lesson, we're going to be talking about the fundamental principles of the UK Constitution. Now, this is going to be the subject matter for the next few lessons, and this is just going to be an introductory lesson to overview and take an introductory look at these principles in more detail. So, thus far, what we've been doing is exploring the various different principles which we can say adheres to the generic theory of the Constitution. So we're talking a little bit more about constitutional theory, the nature of constitutions, the nature of entrenchment of law, the nature of codified versus non-codified constitutional frameworks, the nature of amendments, etc., etc., etc. This lesson is going to look at some of the principles which you will argue are unique to the UK's constitution. Now, not all of them are specifically unique to the UK's constitution in the sense that you can only find these principles within the UK's constitutional framework, but some of them are, and we have our own unique spin on some of the more generic principles as well. So, like I've said, this isn't going to be an in-depth analysis of each of these principles because they are going to be the topic of a series of lessons following this. We're going to talk about them in more detail as their own separate series of lessons. But this is just going to be an overview and an introduction to some of the most fundamental concepts. So, the fundamental principles of the UK Constitution are as follows. If we were to just list them out, we'd be talking about the idea of the separation of powers. We'd be talking about the concept of the rule of law, and we'd be talking about the concept of parliamentary sovereignty. Those are arguably the three most important fundamental principles of the UK Constitution. You may also throw into that mix things like the nature of constitutional monarchy, and we will talk about the nature of constitutional monarchy when we look in more detail at the sources of the UK Constitution and looking at the role of the prerogative within the modern conception of constitutional law. But for the most part, the most important principles that we can think of when it comes to the UK's constitution are the rule of law, the separation of powers to an extent, and also the principle of parliamentary sovereignty, arguably the latter of which being the most important principle. So ultimately, the rest of this lesson is just going to be an examination of each of those principles in their overview, in their generality, beginning first with the separation of powers. Now, arguably, the concept of the separation of powers is something of an ancient doctrine, and the idea here is the rule that power within some kind of constitutional or governmental structure ought to be separated into specific adjudications or specific jurisdictions, or sometimes described as different branches, and these are considered to be branches of government. Now, the aim within the concept of the separation of powers and the fundamental rationale for the separation of powers pertains to this idea of having a government and having different areas of government which are mutually exclusive and separate from each other being able to exercise different kinds of power. Now, at least in the more modern sense, we can talk about the separation of powers from a theoretical perspective by looking at individuals such as John Locke, who wrote his second treatise of government in 1689. And we can see from this sort of Enlightenment political philosophy that the separation of powers is considered to be something of a check on the concept of totalitarianism and the concept of ultimate sovereignty of authority. Something which was increasingly and intentionally being challenged, at least during the Enlightenment period, in a number of parts of the world. Of course, within the 1700s, you see things like the French Revolution. You also see things like the American Revolution, which were considered and are representative of a revolt against this idea of sole sovereignty and all-powerful omnipotence of the monarch. And so, as a result of this, we can sort of contextualize John Locke's thinkings when it comes to the separation of powers in this general mindset, the idea that we ought not to separate authority, that we ought to not have a fusion of powers in the way that ultimately leads to a totalitarian state. It leads to a dictatorship whereby a single individual or a single organization or authority has all of the governmental power, and there is no check or accountability for that power in question. So Locke looks to distinguish along three main branches when it comes to the separation of powers in his conception. He looks to make a delineation between the legislative branch of government, the executive branch of government, and what he describes as a federative branch. Now, where this is a clear elucidation of the separation of powers, it does fail to mention the concept of judicial authority. So, in today's modern conceptions of the separation of powers, we have replaced the idea of federative branches of government with this idea of the judicial, the idea of having a legislative, an executive, and a judicial branch of government authority. Secondly, then, we have the rule of law. Now, the rule of law is, to many people, and in a number of different ways, considered to be the most fundamental principle of the UK's constitution, despite being difficult to define in and of itself. In fact, when we talk about the concept of the rule of law, we can look to individuals who try to elucidate the concept of the rule of law, but do so in a different way. They do so by talking about the fundamental characteristics of the rule of law, rather than trying to delimit a precise definition. According to T.R.S. Allen, for example, in the mouth of a British constitutional lawyer, the term rule of law seems to mean primarily a corpus of basic principles and values which together lend some stability and coherence to the legal order. So rather, in this, as this quote suggests, than just looking at trying to make a definition of the rule of law, a constitutional lawyer may look to the rule of law and find and see a number of basic principles and values, rather than a specific definition. And so along this line, looking at the rule of law is less necessarily about trying to find this concrete and all-encompassing definition that you could just look to a dictionary, but rather looking at a number of basic principles which together form the basis for what we could describe as the stability and coherence of a legal order, and therefore be able to find the stability of this principle of the rule of law. Finally, then, as we look at principles of the Constitution, the last one that we're going to examine is this idea of parliamentary sovereignty. Now, it's a principle which is born out, at least in the most fundamental way, from the Glorious Revolution of 1688. However, when we look at the history of parliamentary sovereignty, we will note that the tensions that existed in the 1600s between the monarchy and Parliament sort of was this slow embryonic development of the idea of parliamentary sovereignty, going all the way up to 1688 and the Glorious Revolution. But what parliamentary sovereignty essentially tells us is that Parliament has the ultimate authority to make and unmake any law they so choose. And so what this means is the Westminster Parliament is the supreme legislative authority within the United Kingdom. And it also means that the judiciary and the courts, more generally, are beholden to parliamentary statute. And so too are the devolved institutions, so things like the Scottish Parliament, the Welsh Assembly, and the Northern Ireland Assembly. And ultimately, we can think about the fact that there may have been some challenges to the principle of parliamentary sovereignty. We'll get into this in more detail when we look at these specifically. But things like, for example, the Human Rights Act from 1998, our former membership of the European Union, as well as this theoretical dividing line that is placed by A.V. Dicey between the idea of legal and political sovereignty, all seem to represent something of a limitation on what parliamentary sovereignty actually is, and the extent to which Parliament is the supreme legislative authority within the United Kingdom.